Passive Pockets is presented by Equity Trust.
Welcome to Passive Pockets, the passive real estate investing show brought to you by Equity Trust. I'm Chris Lopez, your host today, along with my co-host, Paul Shannon. So today we are joined by a friend of the pod, Mauricio Rauld, founder of Platinum Legal Consulting. If you checked him out on LinkedIn, you've likely seen his tagline, raising money, I'll help you stay compliant and stay out of jail. So today, we're going to focus on the legal mechanics that protect limited partners. We're going to clarify what a syndication attorney should do from the term sheet to closing, talk about a 506B Bravo versus a 506C Charlie Basics, how the SEC views capital raisers, and what questions LPs should be asking when looking at deals. We're also going to discuss some hot topics around the accredited investor definition and co-GP structures versus feeder fund structures, and also some common compliance shortfalls, and how to check out the bad actor status. Now, big reminder here, this is an educational conversation. It's not legal advice. Well, with that said, let's jump in.
Mauricio, welcome back.
Thanks for having me, Paul. Always great to be back.
Yeah, it's good to see you. I'm looking forward to our conversation today. I understand you've had some changes over the last year or so. Tell us what you've been up to.
I have. I've kind of transitioned out a little bit. As you guys know from last time, I'm an attorney, obviously. So I founded a firm, Premier Law Group, about 18 years ago. And we specialize in syndication and some asset protection and what have you. But I actually ended up exiting that company last year. So I grew it from zero to, multi-7-figure revenue business, and ended up exiting and selling it to my amazing partner, Bethany, back in November. And I've really pivoted now and focusing more on sort of the educational side. I've got a coaching program. It's really trying to help syndicators. There's so many syndicators right now stepping on landmines. And, when I was at the firm, it's an interesting story real quick. When I was at the firm, I would talk to folks, I do these live events or these Q&A sessions, and they would ask me all these amazing questions, like really good questions. And I just sitting there and I was thinking, these are great questions. Why aren't you asking your attorney? Because I'm not your lawyer. So these are questions you should be asking your lawyers, great questions. And what I realized is that you don't usually hire an attorney until a certain point in the timeline. That's usually when you get into contract. So usually you get in a contract, you hire a syndication attorney to help you with the capital raising process to make sure you raise capital compliantly. Part of that is creating these documents, the private placement memorandum, the PPM, which we can talk about in a second. But up until that point, from the time they decide they want to maybe go raise money or get into this business, all the way through the time they actually get into contract on their first property or their next property, it's a DIY. Like they're out there doing things without an attorney looking over the shoulder. They're communicating with investors. They're making a lot of times offers. They're getting soft commitments. They're posting on social media. All of these, what I call landmines, during a time that they don't have an attorney looking over their shoulder. And so that's one of the things I was trying to address and am trying to address in the marketplace today, which is, hey, why don't we set something up where you do have access to a lawyer like myself, where you can come on once a week or whenever you need a question answered, instead of guessing or learning from TikTok or, doing that kind of stuff. You actually get to get on a call and ask a specific question about, hey, I want to post this on social media. I'm doing a 506B. Is this okay? Or here's my website. Can you please take a look at it? Because I've yet to come across, I'm looking for the perfect 506B website, but most websites out there are non-compliant. So a lot of mess is going on out there, and I just wanted to address that. And that's really what I've been focused on since I left Premier Law Group last November.
Well, congrats on the exit, and the transition makes a lot of sense. So, the vast majority of our listeners are LPs. So, they're obviously downstream of syndicators and the GPs on the deal. So as we go through here, I would like to frame this conversation so LPs can understand, hey, good things that GPs are doing, or maybe some landmines, because obviously that trickles down to LPs. So from the 30,000 foot level, what is the role of a counsel in the syndication process with syndicators? What are they doing? And are the attorneys vetting the deals themselves? What are they doing in the process?
Yeah, great question. So the first thing I would say really high level is that lawyers are no different than doctors, right? So you have different practices in the medical field. There's a general practitioner that if you get a cold or whatever, you would go to see kind of as your first line of defense. And then if they say, hey, look, you've got a problem with your knee, you should go see an orthopedic surgeon. Or if you're pregnant, you go see an OBGYN. Like everybody has a specialty. So a syndication attorney or an SEC lawyer is a specialty, and they focus on anything related to securities laws, right? And what a lot of people don't understand, which is, again, one of the landmines, and I think it's important for LPs to understand this, but anytime somebody is actually raising capital from LPs, right, they're actually aggregating money and the returns are being generated by the sponsor's efforts. Literally, the LP is writing a check and going home. That sponsor, that GP, is actually selling securities, which is kind of a weird thing because usually we're in real estate. So why are the securities laws even coming into play? And the reason is that anytime you raise money from investors where the returns are generated by your efforts, meaning you're doing all the work and the LPs are just writing you a check, you are selling securities, right? And so once you realize you're selling securities, that is a vast web of complex, esoteric, like all kinds of nonsense in the securities world. There's the Securities Act itself, which is back from 1933 and 1934. There's all these regulations at the federal level, which you guys may have heard of. If you hear things like a Reg D or a Reg A, these are regulations that interpret the statutes. There are state regulators. There are state statutes. I mean, there's compliance up the wazoo. And so the role of an attorney, an SEC lawyer that specializes in syndication, which is what I was doing, is to make sure that the GP, the sponsor, is raising the money compliantly. That's the main thing. It's not banging out a bunch of docs. It's not, hey, I just need docs to get to my investors and I'm good. Docs are part of it. It's part of the disclosure requirement because when you're selling securities to LPs, when you're trying to raise money and convince them, hey, I've got a great deal, this is how it's going to work, there's an obligation to provide investors with a certain level of disclosure. So the disclosure documents are important, a key part of it, I would say. But there's so much more out there other than banging out docs. And that's where I think a lot of sponsors get caught up because in their minds, they're thinking, hey, as long as I have a PPM, I'm good. It's almost like my get out of free jail card is I've got a PPM. Bernie Madoff had a PPM. All of the funds that invested in Bernie Madoff had a PPM. That didn't help them, right? So the PPM is not the end all be all. Compliance is the end all be all.
And we're going to dive much more into compliance. I think that was a great summary. But before we get into kind of the nuts and bolts, can we back up just a little bit? Our audience is mainly investing passively in real estate syndications. Typically, those are structured as Reg D, 506B, or 506Cs. Can you kind of just at a high level explain the difference between those two?
Let's step back a little bit. So we just discussed that syndicators are in the business of selling securities, right? And so when you realize that, there's really three things that you need to be aware of as a syndicator and thereby an LP. Number one, you either have to register that syndication or that security with the SEC, or you need to find an exemption to registration, or it's illegal. I kind of like to joke. So you have to register, find an exemption illegal. We don't want to register. We don't want to do anything illegal. So we live in the exemption world, right? And 506B, 506C are two of the most popular exemptions to registration. That's why you always hear that. That's where it fits into the whole area. We're selling securities. We need to find an exemption. Otherwise, we have to do an IPO, which nobody wants to do. So what's the right exemption that we want to use? And for a variety of different reasons, which probably don't need to talk about here, 506B, 506C are by far the two most popular exemptions. I think about 95 or 96% of sponsors use one of these two. And they're very, very similar, except for two pivot points. So let me just go through them real quick. So a 506B is one where you can raise an unlimited amount of money, which is cool. Number two, you can take a limited number of non-accredited investors. So you can take up to 35 non-accredited. Now, what is an accredited investor? It's somebody who has either $1 million in net worth, excluding their primary residence, or on the income side has earned $200,000 the last 2 years with a reasonable expectation of earning that much or more this year, right? So it's very important as an LP to understand, am I an accredited investor or am I not an accredited investor? Because that will dictate what type of investments you can make. And it's really a limitation on the sponsor. Like there's just some investments that are only limited to accredited investors. But the nice thing about 506B, and one of the reasons it's so popular, is that you can take up to 35 non-accredited investors. The downside of 506B is that you cannot advertise. You cannot generally solicit. This is meant for people. It's a private offering. It's people in your network, people you already know, your friends, your family, people that you generally have what's called a pre-existing substantive relationship with. You're not out there on your social media or your website or at BPCon or going on podcasts like this and saying, hey, I've got a deal. You know, if you're interested, we're doing a webinar next week. Come join us. No. This is a private offering. So that's kind of your basics of a 506B. 506C is, again, very, very similar. All of the points, and I didn't go through all of them, but all of the points are identical except for two. One is you are allowed to advertise and solicit in a 506C. That's the exciting part. Like, so now I can go to BPCon with my business plan, pass it out, or I can go on a podcast, or I can go on social media, or I can have it on the website, or I can do ads. I can do Goodyear blimp, Super Bowl ads. You can do whatever you want. The limitation is I'm going to be limited to accredited investors only. So if you're non-accredited, you would not be eligible for these types of deals. And the sponsor must take what's called reasonable steps to verify that you are in fact accredited. With a 506B, if you've invested before in a syndication that's a 506B, they'll essentially give you a questionnaire. You'll check the box. Yes, I'm accredited. No, I'm not accredited. If you're not accredited, maybe they ask for, hey, what is your net worth or what percentage of your liquidity? They'll ask you some questions, and the sponsor can rely on that questionnaire. But when it comes to 506C, where it's accredited investors only, they have to verify. So they can't just take your word for it. They can't just send you a questionnaire. They're going to have to start digging into your financials, your tax returns, or maybe, which is what a lot of people do, is get a letter from the investor CPA that just says, hey, I'm a CPA, I do the taxes for this LP, and I can tell you after reviewing everything that this person is accredited, and then you can rely on that letter. But there is a verification requirement under a 506C. But other than that, those are the two pivot points. Do you want to take accredited investors or not? And do you want to advertise or not? And depending on the answers to those two questions will dictate what the sponsor wants to select, which will then in turn dictate whether the LP is actually eligible. Because if you're non-accredited, you're only going to be eligible for a 506B offering, which is the most common. And there are a couple others that you can also be attracted to, and not to get into the weeds, but one is a Reg A, which is a little bit more complicated, and a Reg CF, or a crowdfunding one. Those are the only three types of exemptions that that non-accredited would be eligible for.
That was a lot of information. It was great. So thank you. And I'm kind of curious. I know this is a hard question to answer, but like, generally speaking, like what % of syndicated deals are done properly, are compliant? You know, the operators are following the 506C, 506B rules, and what type of shortfalls or issues do you see out there?
Yeah, I think the vast majority are doing it right, especially if they're hiring an attorney. Like there are some red flags where people try and cut corners and they're like, they don't hire the attorney, or they don't want to put together PPM because they don't want to spend the 10, 15, 20 grand or whatever it costs for a syndicator to put one of these together. And so they end up cutting corners. And I think that's where it's not only a red flag, but those are the ones that are doing it non-compliantly. And the red flag to me is, you know, if they're cutting corners over here, where else are they cutting corners? Or if the deal itself can't substantiate a $15,000 or $20,000 legal bill, you know, is there really enough margin? Is this really a good deal to invest in anyway? But I would say most people are doing it properly. I think this is one of my pet peeves. I think where most people are messing up is in that time frame that we talked about earlier, the time frame before they hire the attorney, when where they're out there doing it themselves, right? They're sending out email communications and they don't have a lawyer reviewing that and making sure there's nothing in there that'll create a violation or proper disclaimers. Social media is another big one. People are just posting on social media, not realizing that they're actually advertising. So they're really technically blowing their 506B exemption. So that's another concern. People send out underwriting, you know, all the time. And again, there's no legal review. And you've got to remember from the syndicator standpoint is that the SEC, which is the Securities and Exchange Commission, which is the main federal regulatory body, every state's going to have its own regulatory body as well. They regulate not only the sale of securities, but they also regulate the offers of securities. So when you're out there making an offer, and maybe it's most of the time it's unintentional, but if you're out there making an offer and you don't have the proper disclaimers saying, hey, this is not an offer, you can't invest until you have the PPM and you put the proper disclaimers, people tend to make statements in their communications that don't have the proper corresponding risk disclosures in there, and thereby are advertising a deal. And therefore, if they want to rely on a 506B in the future, they're technically, you know, not eligible for it.
Okay, so Mauricio, we've talked a little bit about the compliance issues and what may happen if you're a GP and you don't follow the rules. But as an LP, what happens if you invest in a deal and, you know, you don't have insights into every single corner of how this GP has handled, you know, setting up the structure and what they've done with their attorneys, if they've used them at all. If you've just signed a PPM, a subscription booklet, you know, you assume everything is compliant. But what if they've, you know, taken money from capital raisers that they shouldn't have, or they've got co-GP structures that are non-compliant? We can go down a lot of rabbit holes here, but what sort of recourse does the SEC have against the capital in the deal, and how can that impact LPs?
Yeah, so from an LP perspective, though, it's important to understand that they do have a little bit of a say prior to the investment, right? You said they assume everything's right, they sign the PPM. Well, before you sign the PPM is where all of your work's going to come into play. Like, your job as an LP is to not only vet the deal, I would argue is really vet the sponsor, right? A lot of experienced LPs, I mean, yes, of course, they care about the deal, they care about the numbers, they care about that stuff, but they won't even get there until they've done a deep dive and a due diligence into the sponsor or the sponsor team to understand what's their level of experience. Can they pull off this business plan that they're saying? Do they have experience in this particular asset class? Do they have experience in this particular marketplace? Because you can have a syndicator that's been doing multifamily for the last 20 years, and now suddenly this is a crypto fund or a data center storage or something else, and it's like, well, what level of experience does this person have, or is there somebody on the team? So that part of the due diligence is something that really LPs should be focusing on before they sign the documents, because once you sign the documents, to your point, Paul, you're along for the ride. Usually, you don't have much say into the deal. Usually, there's a provision in there that if there's cause, you might be able to remove the manager, but it's very, very difficult to move the manager. But you certainly are not involved in making day-to-day decisions or making any decisions really as to whether to sell, whether to do this, whether to change strategy. The good news is, to answer your question specifically, is that the number one remedy for an LP, if the sponsor doesn't do it right, is what we call rescission. So let's say in your case, you said, hey, they should have insight into the structure. They can ask all kinds of questions. So when you're on these webinars or before you invest, if you're not clear on how the structure, what's the entity, what's the waterfall, what's the preferred return, if you have any questions, or, hey, is there an indemnity? Any question you have, you should be able to, not only should be, but you're legally entitled to have those questions answered by the sponsor. So I'm going to push back a little bit about, hey, I just don't know what's going on in terms of that side. Now, you're right. If the person raised capital illegally because they brought in GPs and they're paying capital raises, or they're doing something, or maybe they failed to disclose something, you wouldn't be able to pick something like that up. So if the sponsor does something improper and violates securities laws, the remedy for that is rescission, which means they have to give all of the money back to the investors plus interest. So the regulator will have them return the money. They'll have to pay penalties and interest, but the interest will go to the investors. And the idea then is that essentially, this is what I tell my clients, is like, hey, if you don't do this properly, you're essentially guaranteeing the investment, because if the investment goes well, great, and the investors get their money back and their returns. If the investment goes south, they're going to get their money back plus interest because of the rescission. Now, let's not kid ourselves. The reality is if the deal's gone south, even though there would be entitled to rescission, my guess is it's gone south. There's nothing there, right? The property's underwater. There's no equity. And so the sponsor will end up filing for bankruptcy, and there might not be any real recourse. But technically, what they have is a right of rescission, which means, hey, I want to unwind this transaction. I know I gave you $100,000 a couple years ago, but because you violated securities laws, I want to unwind that transaction, give me my $100,000 back plus interest. And that's the remedy that they would have.
So you mentioned a few minutes ago about hey, a lot of times investing in these deals, we're looking at sponsor due diligence. So I'm having you put your LP hat on for a minute, so to speak. And I know you invest in a lot of deals. What are some questions that you like to ask as an LP, as you're vetting GPs? And are there certain documents that you request or processes that you like to verify?
Those are two separate questions. So the first one will be on the sponsor. So the questions I want to ask about a sponsor is, first, understand who's on the team, right? Because you're probably dealing with one individual, but how many people are on this co-GP team, which is another one of my pet peeves in general. There's one thing if there's 2 or 3 or 4, maybe even 5, right? Maybe tops, that's the GP team. But I've seen deals where there's 13 of them or something. And I'm I don't know what all 13 are doing. But you're probably talking to one of the sponsors. And so you want to understand who else is on the team and what is everybody doing. Because a lot of times you're talking to person number one, and then once they're giving you all the info, everything's great, you get a relationship with them, then you invest, and they disappear. You're not talking to them, you're talking to somebody else on the team. So you want to know who's all on the team. And I say, again, what is their level of experience? How long have they been doing this? Is this their full-time job, or their part? Do they have W-2 jobs that they work 9 to 5 and this is something they're doing on the side? Or this is full-time, this is all they do? How long have they been doing it? What's the area of their expertise? Again, go down to the asset class. If this is a mobile home park syndication, who's on the team has experience on the mobile home park, or who on the team has the self-storage, or whatever the asset class is? How long have they been doing it? Let me look at your prior stuff. Ideally, which is tough to do, you're talking to prior investors. And I know there's a lot of forums. I know you guys are responsible for some of them, where people can go on these forums and just start asking around, hey, has anybody invested with Bob? Has anybody invested with Jane? And people will give you feedback. These days in the world of social media, it's not difficult to get feedback. Now, I will say that on the feedback side, it's just like any reviews, right? The negative people tend to rise to the top, and you get more of that. But all that kind of due diligence is what I like to do. On the due diligence on the actual deal itself, you just want to follow the money. They're telling you, here's the business plan. Here's how it's going to work. And I would just trace the money step by step. And it's easier for me because I'm an attorney. Even though I'm not your typical lawyer, right? But I'm still sort of the left brain or whatever. I'm very analytical and I'm very compartmentalized. So for me, it's like step by step by step. Like I would draw a timeline. And I would say on the left side is money coming into the system, whether if it's real estate, it's a tenant, right? If it's something, who's buying the product, how are we getting revenue? Then how does it go to every single step until the very end, which is where I as the investor get paid. And each chain, I want to verify with docs or ask about how do I prove? So if you're claiming that this thing rents out for XYZ, show me the proof. Like maybe you want to look at rent rolls. Maybe you want to look at the details if it's a real estate deal. Like where's the revenue coming from? Like, and has it been there? And if they're claiming that, rents are going to go up and the market rents are Y, they're going to go for rents from, 1,000 to 1,500 or whatever the value add is, then there's ways to verify that. Ask them, where are they getting these numbers from? They're probably going to tell you it's a property manager. Then you can call the property manager or you can do your own research to find out comps. So I like the chain because the deal is only as strong as your weakest link. The other reason I like the chain is because unfortunately I have been parts of several illegitimate deals where they're literally Ponzi schemes, right? And so if you don't verify, trust but verify, if you don't actually verify the existence of whatever the representation is, you're relying on them. And, maybe there is a tenant, maybe there isn't, maybe there is a contract, maybe there isn't, maybe if it's not real estate, sometimes there isn't even the underlying asset. So, that's another thing you might want to consider is going out and doing some, again, it depends on the level of investment too, right? Like if you're going to invest 50K, you're probably not going to hop on a plane and go take a look at the asset and do something up. But if you're going to invest $1 million, that's when I would start getting onto planes and stuff and flying down and actually, checking out the piece of real estate or meeting with the team, checking out their operations and things like that.
There's a lot to unpack there.
Yeah, I know. Sorry. I talk a lot, Paul. I apologize.
That's great. I love it. There's a lot of information here, which is valuable for the listeners. But to touch on specifically a few of your last comments there related to Ponzi schemes and fraud and potentially bad actors, is there a place where LPs can go on the internet to find out, SEC bad boy list, so to speak, and kind of conduct their own due diligence to see if there's any pending litigation or they've actually been convicted of anything, improper in the past? Is that something an individual can do on their own?
Yeah, no, there's absolutely now. Whether they can do it on their own, probably not. I mean, you could probably figure out how to do it on your own, but it's not free, right? So for example, on criminal background checks and civil background, yeah, you can search the internet. Maybe you can Google, maybe you can go to page all the way down to the end. But really, there's specific software like a LexisNexis, or just something that's usually law firms have them, and they're just not cheap, right? So it makes sense if a law firm has it. Even for me, like a solo practitioner, sometimes it's, man, it's kind of expensive. I don't necessarily need it, but if I was in litigation, I need access to court cases, I would have LexisNexis, and it might cost me $1,000 a month or something, or 12 grand a year or something. So it's not reasonable to do that. But there are services out there. There's several services out there that will do those kinds of searches for a relatively nominal amount. When I say nominal, somewhere in the $500 to $1,000 range, you can pay somebody. It's not the level of a private investigator, right? But they'll have access to all these things. They'll run a check, see if there's been any complaints, any civil, any regulatory action, anything like that, to give you some level of confidence. But ultimately, the true would be to go hire a private investigator. But again, that's going to cost you significantly more. But I've already seen several that are popping up that for $500, $600, $700, they'll do that sort of bad actor check, which the sponsor should be doing on their own. They should be bad actoring or bad actor checking each other. And again, if there's a bad actor in there, they didn't disclose that to you, that would be grounds for rescission. Give you a little pro tip. If you're in a deal that's maybe going okay or however it's going, and you find out later that one of the sponsors is a bad actor and that wasn't disclosed to you, then you do have rescission rights. So you could pick up the phone and talk to the sponsor. Hey man, you didn't disclose this to me. I want out. I want this deal rescinded. Otherwise I'm going to go, call some regulators.
Do you have any specific service recommendations that isn't LexisNexis out there? Because I've used background checks in the past for deals I've looked at and deals I've structured. Like, are there any specific third-party services that you would recommend?
Not off the top, man. I mean, I know there's a couple of individuals that do it. I don't know if I want to necessarily promote them, but I'm happy to point you guys in the right direction of a few that I've known. I just haven't used them. Actually, one of them I'm in talks with. I am planning on using, but I haven't done that, so I don't necessarily want to recommend something that I haven't actually seen.
Understood. All right. I want to talk about capital raisers. So how does the SEC view capital raisers? And then what activities can a capital raiser do and can't do before they cross over to a broker dealer, which is, a licensed broker dealer type role?
I generally don't like the term capital raiser, because the term capital raiser implies that you're raising capital, and that's a licensed activity, right? It's no different than you can't practice medicine without a license. You can't practice law without a law license. You can't be a capital raiser, a true capital raiser, without a broker-dealer license, right? Right now, the general rule is in order for you to raise money for a syndication, and this, by the way, this is another thing that people just don't know, right? Sponsors don't know this because they just assume this is how it's been done all these years, and they don't realize there's a reason for it. And because they don't know there's a reason for it, they tend to get into trouble because they're like, well, wait a minute, why can't I do this if I've been doing it this way all along? So the general rule always is that every single sponsor or syndicator, unless they're doing it by themselves, right? Unless there's just a one-man or one-woman show. But if there's a group of sponsors, they are technically raising capital for others. They're raising capital for their syndication entity, right? So the general rule is they would need a broker-dealer license. However, there is an exemption, right? This is called the issuer exemption. So most syndicators, 99% of syndicators, the reason you don't see them getting broker-dealer license is because they fit into this thing called an issuer exemption. But in order for them to fit into that exemption, they have to do all three of these things. Number one, they cannot get paid transaction-based compensation, meaning they can't be compensated in the syndication based on whether they bring in money or how much they bring in money, right? And that's where some of these third-party capital raisers get into trouble because that's what they do. They say, hey, man, I can bring in X amount of dollars, and in exchange for me bringing in X amount of dollars into the syndication, I want to get paid X amount of dollars, a commission or a percentage of the company or what have you. But no transaction-based compensation is number one. Number two, they have to be doing what's called substantial duties. So again, if you're a syndicator, if it's two or three of you, then you're doing all the work, right? You're doing the due diligence in the marketplace, you're flying down, you're underwriting, you're getting into contract, you're talking to lawyers, you're underwriting, you're due diligence, you're doing it all, right? And you split that between 4 or 5 people. Everybody's doing substantial work. And the third thing is that they must be doing their primary role in the syndication needs to be something other than raising money. Like your primary role cannot be the capital raiser. You have to be doing more than 50% of your time has to be that substantial duty, whatever that is. Right. And so again, for most syndicators, no problem. Like if it's you and 2 or 3 or 4 of the partners, you're not getting paid transaction based. You're getting paid for putting the deal together, for for doing the whole thing. Right. You've all got substantial duties, right? Because you're actually in the deal. And your primary role is not raising capital. Your primary role is finding the deal, getting the deal into contract. And then sometimes people forget you're asset managing the sucker for 5 years, right? Especially if it's multifamily or anything. So you're spending 5 or 6 years working on the business itself. And that's really what the SEC wants to look at is like, what are you doing after you close on the securities raise? After you've raised all the money, what are you doing? What role do you have in this deal? And so if you're asset managing and you're running the project, then obviously, but when you have these quote unquote capital raisers, they usually fail all three. What tends to happen is they're basically illegal capital raisers that are trying to make the facts such that they fit into this exemption, even though realistically they don't. It's like that, what is that, fitting the square peg in the round hole or whatever it's called. They're trying to fit that in there. And so they're trying to almost manufacture or hide or whatever. And again, the SEC doesn't care about titles and, they're going to look through all that and say, hey, did this person, this third party, did they get transaction-based comp or did they get compensated for bringing value to the deal? And when I say value to the deal, again, maybe the 3 of us are a team and we're doing our deal and we want to expand to a new market like Florida. It's like, we don't know anything about Florida or we all live nowhere near Florida. So let's go find a 4th person to come in who's boots on the ground, who knows that market really well, and they can be the Orlando specialist or the Miami specialist. Or maybe, like we said earlier on the asset class, right? Maybe we're multifamily guys, or we do single family, whatever we do, and then we really like this whole idea of self-storage. And so, we don't really know much about self-storage other than what we've read in the last couple of weeks. So let's bring in a self-storage expert who's got years of experience, who knows the thing, has a relationship with brokers. That's how you legitimately bring these kind of co-sponsors or co-GPs in the deal. But if you primarily bring in a co-GP because they've got resources, they've got money, they're going to be an unlicensed broker, which will cause the whole syndication you're not disclosing that to your investors, right? Because so you now have a fail. Why would you disclose it? Hey, I'm paying Paul, who's an unlicensed broker. So you don't disclose it to an investment. So you have I don't say illegal, a non-compliant offering. And then you go back to these rescission rights that you would have as an LP.
Mauricio, I think Chris asked you this earlier in the conversation. What percentage of deals do you see that are structured improperly? And as someone who's an LP, but has also structured a few funds and done a couple single asset syndications, this is the number one thing that I see as being non-compliant. Either it's transaction-based compensation, or you've got 9 co-GPs on a deal that live all over the country and certainly don't have substantial roles beyond just bringing the capital. And I've probably turned down more opportunities to be on a team because of these reasons. And it hits home. I think that's something that LPs should be asking when they get involved in deals, back to your point about who's on the team and who plays what role in the team so they can have eyes wide open when they go into an investment.
Paul, the number is important. I mean, I think it's very similar to the analysis when we do joint venture agreements and joint venture structures. Like once you get past 5, it's tough to argue that everybody in there is doing substantial. And then plus, why would you have more than 5? You're just diluting yourself. If there are really 5 people, how many people do you really need to go run an apartment complex? I mean, yes, you need a few, especially if it's a big one, but you don't need 9, right? I guarantee you somebody on that 9 team or several were there primarily to bring in capital, and they're just manufacturing, substantial duties. Oh, we're showing up to the meetings, or we're doing something like that. And again, if you get audited, and that's really, let me just backtrack, that's really where the issues come into play, right? It's not necessarily that the SEC is actively scouring through the internet or spot checking syndicators. It only really happens if something goes bad, right? If something goes bad, that's where the SEC or the regulator would open up investigation. They start doing audit. They start asking for questions. And that's where they'd uncover, oh, wait a minute. Hey, Bobby, it looks like you own 6% of this company. What did you do for the 6%? Like, I don't see you really doing anything. And their answer cannot be, I primarily raised money.
Well, is that why you're seeing a trend from what used to be really, really popular was to have a bunch of co-GPs that were bringing in capital, and now you're seeing more funds of funds?
Yeah, so that's a great observation. So, 5 years ago, 6 years ago, this co-GP thing was getting out of hand. I mean, I think had one where I think there was 14 or something, some crazy number. And again, there's only so much I can do. Like you advise, I've had so many funny stories where I'll literally say, look, you can't bring any, you can't do this, can't bring him in, you can't pay him, you can't, I get it. And then I find out later that sure enough, they brought somebody in, after the fact, so there's only so much we can do. But there was so many co-GPs, it was getting out of hand where clearly not everybody was doing substantial duties. Clearly somebody was there to raise capital. And so this idea of the fund of funds started really becoming prominent, I would say right around COVID. I think, prior to COVID, I don't think I did that many funds in general, let alone fund of funds. And then after COVID, this thing started happening. But now we just have a different set of problems. Like it's like another set of regulations, because what happened is like people who were good at bringing in capital, instead of just coming in and referring people to the GP and becoming a co-GP in the deal, they would create their own syndication, which can be done properly. So they would set up their own LLC. They would bring in all of their investors into their LLC. They would do that properly. They would get a PPM. They would it's a security. So they would either register, find an exemption, or it's illegal. They'd rely on 506B, or they'd do that properly. And so then they would, let's say, raise $1 million into that little fund. And then that person would turn around and put it and invest the $1 million directly into that sub syndication, right? Which is fine. The challenge, though, again, you don't think of these things. I mean, it's not your job to think of these things. So it's not like I'm blaming anyone. But when you are investing in real estate, which I'm assuming everybody here who's listening or at least has some interest in real estate, you don't need a license to buy real estate, right? You can go buy real estate. I don't have to go do any special license to go buy a multifamily, a single family, a mobile home. I don't need a license. But when you do a fund of funds, you're no longer investing in real estate. You're investing in shares of that company, LLC units, right? You're an LP in that company. So now you're raising money from your investors to go acquire securities. And that opens you up to a bunch of other regulations that you don't have to even think about when you're just purely doing real estate. So you have things like the Investment Companies Act that comes into play, which you really want to avoid. So we got to figure out how do we get around the Investment Companies Act. And that's probably, if you've ever heard the term, make sure you have less than 99 investors or 100 investors. That's where that comes into play. That one of the easiest exemptions is what's called a 3C1, which if you have less than 100 investors, you're good. The big one, though, is that because you're advising your fund, the fund of funds, you're advising your fund as to the purchase of securities, as opposed to the purchase of real estate, you now become an investment advisor. And so then the question becomes, do you need to register as an investment advisor, or what do I have to do? Okay, cool, I'm an investment advisor, so what? And that's where we have to get into most likely state by state regulations. Almost every single state has an exemption, but you've got to fit through the exemptions. Some exemptions have limitations, but a lot of people don't want to deal with that or don't look at that. And so they bypass that whole thing. They just raise a bunch of money into their fund. They make an investment into the underlying fund, and they don't worry about out and don't even pay attention to whether they're violating their state investment advisory rules. And then, by the way, broker-dealer rules come into play as well, because if all you're doing is raising money into your fund, but really you're raising money for the underlying syndicator, you just kind of have this smoke and mirrors of just a bunch of entities that are in between. You still have to worry about looking like you're really just raising money for the benefit of the underlying syndication. So there's just a lot more regulations. And of course, people don't like regulations. And there's a lot of companies now have popped up trying to make it look easier than it is and ways around it. And those are all mostly nonsense. Can I just bring up one that's kind of becoming a pet peeve of mine? Because for some reason it's popping up a lot. And I'm sure a lot of the LPs have been hearing about this. And again, there's some AI apps that I've been seeing popping up. And this is this idea of investment clubs. Like somehow by putting together an investment club, you're somehow avoiding, again, there's always like, oh, we can get around the securities laws by doing this or by doing that. Again, let me remind you, the securities laws have been around for almost 100 years now, since 1933. They've seen every trick in the book. And although it's true that the SEC does not specifically regulate an investment club, meaning if you want to start an investment club, knock yourself out, just like they don't regulate a creation of an LLC. Like they don't regulate the LLC creation. You want to create a company, they don't regulate that. But how you structure and put your investment club together, if you start aggregating a bunch of passive investors, and again, you start raising money from those passive investors in order to make a return and make an investment, that's a security. You either have to register, file an exemption, or it's illegal. So this idea that the investment club somehow cloaks your securities offering is nonsense. So what most investment club promoters try and do is they try and couch it as a joint venture. They're saying, well, it's not really securities because it's a joint venture. And so then we go into the conversation about, what's a true joint venture, but you certainly cannot have a joint venture with 27 investors.
This is a great topic. So I want to dig deep in this for a second because, Paul and I, we talk about investment clubs and different ways to, structure, hey, we want to pull money together so we can, each throw in some money and then we can access a bunch of deals and have a very small check into bigger deals, right? So the investment clubs, are you saying you don't like them in general or you don't like them once they're past a handful of people?
I don't like the idea, which is what's being promoted, is that it's a way around the securities laws. If you're a listener right now and this is something of interest to you, just go and Google SEC investment clubs. And the first thing that's going to pop out is a website or a page from the SEC that talks about investment clubs, right? And that's the same link that most of these guys point to as, hey, look, the SEC themselves has says that we don't regulate the investment clubs. But then you read 2 lines below that, and it still says like, hey, these are facts and circumstances. So you can still, whether this is a security or not is a facts and circumstances. Are you taking money from passive investors where the returns are generated by your efforts? That's what we call the Howey test. It's the English version of the Howey test. But like if you are doing it in such a way that triggers it being a security, it's a security. Whether it's in an investment club, whether it's in a Hawaii club or like however area it's a meetup, like it doesn't matter. The structure itself never matters. The SEC is going to look at the arrangement and they're going to say, is somebody here or a group of people taking money from passive investors where the returns are generated by their efforts? If the answer is yes, it's a security. If you structure an investment club where it's Paul, Chris, Mauricio, like 4 people, and every week all 4 of us get together and every week somebody brings in a new deal and we roll up our sleeves and we all dig deep into it and we say, man, this looks like a great investment. Let's each put $50K in and we'll make a $200,000 investment. That's probably fine, right? But if you're trying to be like, oh, I've got 75 people in my club and I present an investment to everybody, and then 8 of them say this is a good idea and they put it into my LLC and I manage the whole process and I'm the one generating the return and doing most of the research and the due diligence, that's a security. The fact that it's an investment club in and of itself, that structure is irrelevant. It's really what's going on underneath the hood. Is it structured in such a way that would trigger securities laws?
So Mauricio, we may have to do a separate podcast in the future just on investment clubs.
I would love to, man. I'm actually, you know what? I have an ebook that I've been meaning to update for many, many years. And I think I'm going to add that as a chapter because it's called The 5 Things Every Syndicator Must Know to Stay Out of Jail. And I'm going to add that investment clubs are not like a get out of jail free card.
All right, updated ASAP. Let's get it back on the pod because actually myself, Paul, Jim Pfeiffer, and a few other people at the PassivePockets were talking about, hey, we have a lot of deals coming on our show. Hey, let's form an investment club. We can all look at it, review it. If we agree to invest, we'll each pitch in $50,000 and then we'll write a $50,000 check across it. So, and there's a lot of topics in the PassivePockets forum. But this brings me to our next question. Why does every single lawyer have a different interpretation of the rules, the code? I remember early on as I was getting into understanding this space, structure-free deals, I talked to 4 lawyers and the extreme. One lawyer, you're going to go to jail. The other lawyer is like very loosey-goosey. Why the heck do you all have different opinions?
It's like my favorite CPA joke. If you ask 3 CPAs the same question, you get 5 different answers. And it's true for lawyers too, right? You ask for 3 securities lawyers, you're going to get 5 different answers. And the reason why is because there's no black and white answer. This is all a lot of gray area. And so you can't just look at a statute or even the Reg D. You can't just be like, oh, you have to have a pre-existing substantive relationship. And you're like, well, what does that mean? And so you have to keep going into case law. And some people have done more research than others. Some people may have found a specific case. Like I was doing research for a client on a joint venture. I was trying to make this a legitimate joint venture. There's literally 3 people in there, but the economics were a little off, wacky. And so I'm like, I'm just not sure. And so I started doing a deep dive and I came across a case that was spot on that told me, hey, just because the economics are wacky, maybe there's 2 of you and it's a 50-50 deal, but 90% of the profit is going one way versus 10. I found a case that was spot on. And so from now on, I'll hang my hat on that statement. But if another lawyer hasn't found that case, then they're less likely to do that. The other thing that's very, very important is just like past investors, as you guys know, they run the gambit. There's super conservative investors that want to put their money into the money market accounts and like my mom, anything that's not in even a money market account, might be like, I don't even know what that means. That's risky. And then there's other people that just want to go to Vegas and put it on black. Like how many of the BP Con alumni just went and put on black this last weekend, right? And there's everybody in between. And so it's the same for syndicators, which is like, hey, how aggressive? Some syndicators, some friends of the podcast are very, very conservative. They don't want to go anywhere near the gray line. They want to stay as far away as possible. And other people are like, dude, let's go right up to that thing. And just as long as we're not officially committing fraud, like let's go there, right? And I think it's the same thing for lawyers, right? The lawyers, everybody has a different sense of, are they conservative? Are they a little bit more willing to do things? One of the things you have to keep in mind, and this is probably a good tip as kind of an insider for a lawyer, it depends on how much you're paying me, right? But let's say we're doing a deal and you're hiring me and let's say my bill at the end of the thing's gonna be like $5,000 or something, I don't know, or 10 grand or whatever. That's what I'm paying for my services. You're asking me for an opinion or something and you want me to go out on a limb on something where if I'm wrong, I'm going to get in trouble. I might have a malpractice claim against me. It might cost me $100,000 just in legal fees. And I'm like, why would I advise that person? Oh yeah, you can definitely do this when, man, if I'm wrong, you can come after me for advice of counsel. And so there's a risk involved there. So there's a risk for the attorney and some people are more risk averse than others. I think I tend to be, although I've been accused of the opposite, but I tend to be thinking myself as more creative in terms of how to structure things. And like, for example, I'll give you a great example. Like most lawyers, I think in my world, they don't like referrals, for example. But I'm a believer based on everything I've read and even some SEC statements that if an LP refers somebody to that sponsor, even though the sponsor does not have a pre-existing substantive relationship, that's okay. Now you can't pay the referral because you can't pay a referral fee, but that even though you don't have to have a pre-existing relationship. Other lawyers will say, no, you can't do that. You have to have a pre-existing relationship. I would then just point you to an SEC website or some case law that shows, hey, having a pre-existing relationship is one, but not the exclusive way that you can show that you didn't. So anyway, so things like that. And just depends on how deep of a research, because the more prepared, the more research you've done on a topic, the more confident you are of giving a particular statement, especially if you've been able to find case law out there that's just spot on to whatever your issue is. And what I haven't done, which I'll do, I promise to do this, what I haven't done, because it's literally just been popping up in like the last month. I don't know what's going on. If there's something happened, I will do a little digging around to see if I can't find any case law that specifically addresses, because that's what I would do. I would go look at case law and see, has there been a judge or an appellate court that's already ruled on, whether this investment club was a security and went through their analysis. And that way I can actually talk about, hey, this is the analysis these judges are making. And then we can apply it to our specific facts. That's how you do it on the legal side.
Well, I appreciate the conservative yet creative approach, and I would encourage everyone to stay way far away from the edge of risk, so to speak. So we're getting towards the end of the conversation, Mauricio, but I think Chris and I are both interested to hear your take on this one. There's been a lot of things changing. There's talk of changing the accreditation status or definition of accredited investor from $1 million net worth to $3 million. There's tokenization. There's private placements entering into retirement accounts. Where do you see the space evolving over the next, call it 5 to 10 years, and what will it look like then?
Yeah, I think there's a lot of changes. A lot of them already come up. I actually made a video on my YouTube channel back in whenever Trump became, I think it was November. And I made a few predictions. Some of them were easy, like, bonus depreciation coming back. I felt that was like a no-brainer. But there's a couple that are really, I think, are on the verge of coming back, which in my space, in the syndication world, is huge, and especially for LPs as well. And that is, My prediction is that by the end of next year, so in the next 18, let's call it 12 to 18 months, you're going to see the accredited investor definition expand to include the ability to just take and pass an exam and become accredited that way. I'm not going out on a limb. There's actually already an SEC rule that was passed in the first Trump administration that actually stated that. So actually, there's a rule on the books that already says that if you go take an exam from a certified accredited institution, that you will become accredited by taking and passing that exam. It's already on the books. The problem is nobody has been certified to, or institution to issue that exam, right? That was a stumbling block. So that's the only thing that needs to happen there. But the new SEC commissioner is just big time into helping people raise capital. We call that capital formation. He's big into trying to loosen the regulations to make it easier for people to do. So I think the accredited investor definition is a no-brainer, is coming down the pipeline. I do think if you want to go 5 to 10 years, that they are going to be increasing, you mentioned it, Paul, they are going to be increasing the net worth requirement probably to about 3 million. So instead of being $1 million, now it'll be 3. Why 3? Just adjust for inflation. 1982 is when this 506B, which just was called 506B back then. I'm sorry, it was called 506 back then. That was when the $1 million came in. If you just adjust for inflation back from 1982 to today, you're at about 2.8, 2.9 million. So 3 million makes sense. They've also come out with a report making that same statement. They've also indicated, and this is something I didn't even think of, possibly excluding, instead of just excluding your primary residence, excluding your IRA funds. Okay, so that'll make it a little bit harder to become. That's another thing they've looked at. And the other thing they're looking at too, which also makes sense, I didn't think of this, is having different definitions depending on what area of the country you are. Because obviously $1 million in California is a lot different from $1 million in, rural Arkansas or whatever. They're looking at that. They came out with a report almost 2 years now in December of whatever 2 years ago was. So that's coming. The other thing that I'm really excited about, which we talked about it on this podcast, and that is this idea of this finder rule, which we mentioned that you can't raise money for others. We talked about the capital raising unless you fit into the issuer exemption. That's right now the only exemption that's out there. They, again, had a proposed rule during the Trump administration where they would allow people to make introductions, to actually make introductions to sponsor and get paid a commission for doing so. And being somewhat involved in the deal. Now, not making recommendations, but hey, Paul, my buddy Bob over here, he's interested, he's got some money. I'd like to make an introduction. Let's schedule a call together. And I can make that introduction, connect you guys, maybe even show him some of the documents and kind of helping through that process. And then if we have a commission arrangement where if that person invests in your deal, we agree that you're going to pay me 5% or give me 10% of the GP or whatever. I think that's probably not as an easy call, but I made that call back in November. And sure enough, about a month and a half ago, they reapproached that proposed rule from 4 or 5 years ago. They're looking into it again. And I would suspect here in the next 6 months or so, they'll probably reintroduce that proposed rule. And so I think by the end of the Trump administration, you'll have that finder rule in place. Now, it might be tweaked with the proposed rule right now. But essentially, I do believe there is going to be a method now for you to refer people and basically raise money, hand them over to you, and get a transaction-based comp, so a commission or a piece of the GP, and doing that legally, which will be super. I know some people think it's a bad thing. From my perspective, it's a great thing.
It's interesting to hear about these insights. I'm excited to see where they go because I think the more clarity and as things get updated for industry, the better it is. But I got a really important question for you that was in the PassivePockets forum a few days ago. What is going on with the Drunk Real Estate podcast? It's been, I think, 6 weeks or so since the last episode. And some brought up there and said, hey, are you guys just really hungover or what's going on? It's been a while since you released an episode.
Yeah, unfortunately, we had to kind of I think it's going to be a pause, but we were just getting super busy. I think people assume we just show up and have some drinks and, shoot the what. And I wish it was that, but there's quite a bit of prep going on. And, with my transition going on and all the stuff that's going on my plate with AJ, running his stuff and Bar Down, we were just being a little bit time constrained. But I talked to Jay at BiggerPockets, BPCon, and I think he's going to try and reboot it somehow because I know I've gotten a ton of DMs as well, and we never really made a formal announcement, which we probably should. And so I talked to Jay about maybe making a formal announcement. But right now, let's call it's on hold. We haven't released an episode, I think, in probably 6 or 7 weeks.
All right. Well, that was my hard-hitting question for you. But as we wrap up, where can people follow you and just keep learning from, all your knowledge?
Yeah, if you have any interest in raising capital or either on the LP or the GP side, I'm really active on LinkedIn. That's probably my number one platform. I try and post daily and I'm just trying to give value there. If you have any specific questions for me, you can always just go to askmauricio.com. That's askmauricio.com. shoot me a question, and I'll probably answer it probably in the form of a social media post, but happy to answer those questions.
Awesome. This has been fun, Mauricio. Thanks so much for coming on the show.
No, thanks for having me. It's always fun to be here.
All right, well, that was a great show we just had. We dove into a lot of topics. We clarified how deals should be structured, the difference between a 506B and a 506C, where we see compliance issues a lot, and how LPs can verify sponsor integrity before investing. So the key takeaways here for passive investors are simple. Ask about the process, expect documentation, confirm verification paths, and do checks on the sponsor history with their background checks. So a big thank you to Mauricio for helping our investment community go into deals with their eyes wide open. So for more conversations like this and to connect with other LPs, make sure you go to PassivePockets.com to join our private discussions in the forum. Thanks for listening, and as always, happy investing.